the president of the American Constitution Society, and I'd like to welcome you to tonight's virtual event, the 19th Amendment Centennial and the ongoing fight for women's equality. I would like to take a moment to lift up our members in California, Louisiana, and Texas as they face extraordinary natural disasters. And I would, of course, be remiss not to also lift up those in my own home state of Wisconsin, where I am right now, who are demanding justice and accountability for Jacob Blake and his family after this week's police shooting, as well as the victims and the families of the victims of those that were killed in Kenosha last night. We are here at ACS with your thoughts, with our thoughts very much about you. August 26th is Women's Equality Day, a day filled with important milestones on the path toward gender equality. 100 years ago, suffragists were celebrating ratification of the 19th Amendment, which enshrined in our Constitution that the right to vote shall not be denied or abridged on account of sex. 50 years ago, feminists took to the street as part of the women's strike of 1970, calling for change that would more fully realize women's equal rights. Among their demands, an equal rights amendment and free childcare. In 2020, women are still organizing and fighting for their right to vote, for childcare, and for equality under the law, including the explicit inclusion of an amendment to the Constitution guaranteeing equal rights for women. We are coming together on a night when, once again, calls for equality are ringing through the air. In Louisville, activists are demanding justice for Breonna Taylor and reminding America that Black women have been denied justice in this country for far too long. And across the country, COVID-19 pandemic conditions continue to fundamentally change the way we are living our lives, with, of course, childcare disproportionately falling on women. Right now, so many families are wrestling with incredibly difficult decisions about their child's education and care as the traditional start to the academic year arrives without a vaccine. But tonight we celebrate and take stock of the hard-fought gains achieved by generations of women. But we also look forward to what still remains to be done to achieve true equality under the law. Now, before I introduce our moderator for tonight's panel discussion, just a couple of housekeeping notes. This call is being recorded, and the recording will be available after the call on ACS's website at www.acslaw.org. We'll be taking questions after our presenters are finished with their remarks. If you'd like to ask a question, you can type it into the Q&A box at the bottom of your screen at any time during the call. And of course, we'll try to get to as many questions as possible. Finally, 1 hour of California, the CLE credit is available for this call. Please email us with your women's equality in the subject line at info@acslaw.org to receive your certificate. If you're seeking CLE credit in a jurisdiction other than California, please consult the rules of that state CLE board to see if it provides for reciprocity with California. CLE materials can be found on the event page of the ACS website and will be shared with all the participants in a follow-up email. Now, to lead our conversation tonight, we are very delighted to have Professor Melissa Murray with us as our moderator. Professor Murray is the Frederick I. and Grace Stokes Professor in Law and Faculty Director of the Birnbaum Women's Leadership Network at New York University Law School, where she teaches family law, constitutional law, and reproductive rights and justice. She is a co-host of the Strict Scrutiny podcast and frequently offers commentary for leading publications and national news networks. We are very proud to have Professor Murray on our ACS board of directors and our board of academic advisors, and thankful to have her with us tonight. We have a lot of ground to cover, so let me now turn it over to Professor Murray to get us started.
Thank you so much for that kind introduction, Russ, and welcome to all of you in the audience. We're so glad that you joined us today on the 100th anniversary of the ratification of the 19th Amendment. Our panelist tonight is star-studded and really steeped in the history of not just the 19th Amendment, but the women's rights movement more generally. So I am delighted to introduce you to first, Senator Jennifer Mcclelland. Senator Mcclellan is a state senator representing Virginia's 9th district, which includes Richmond. Prior to her election to the Senate, Senator Mcclellan was a member of the Virginia House of Delegates for 11 years. She's been a leader on improving education, breaking the school to prison pipeline, criminal justice reform, expanding access to affordable housing and healthcare, combating domestic and sexual violence, diversifying Virginia's economy, civil rights, and ethics reform. As the only House member to be pregnant while in office, she has been a fierce protector of women's reproductive rights, children, and families. She's a graduate of the University of Richmond and holds a law degree from the University of Virginia. Wahoo wah, welcome, Senator Mcclellan. Also with us is Reva Siegel, the Nicholas D.B. Katzenbach Professor of Law at Yale Law School. Her writing draws on legal history to explore questions of law and inequality, and to analyze how courts interact with representative government and popular movements in interpreting the Constitution. In the last year, Reva joined Kate Shaw and me as co-editors of Reproductive Rights and Justice Stories, and published articles in a variety of areas, including the 19th Amendment and the Second Amendment. She is well known to ACS members as a member of the ACS Board of Academic Advisors. And then last but not least is Julie Soup, the Dean of the Master's Programs and Professor of Sociology, Political Science, and Liberal Studies at the Graduate Center of the City University of New York, as well as the Florence Rogetz Visiting Professor of Law at Yale Law School. Prior to joining the CUNY Graduate Center, Professor Soup was a law professor for 13 years at Cardozo Law School. She is a scholar of comparative law and society with a focus on women and comparative constitutional law. And her recent book, We the Women, The Unstoppable Mothers of the Equal Rights Amendment, describes the ERA's long legislative history. So just to provide a little roadmap for tonight, we will spend about 30 minutes talking with the panelists about the 19th Amendment and its connections to women's equality and equality movements today. And then we'll shift into questions from the audience. So please feel free to leave your questions in the chat, and we will try and get through as many of them as possible. But let me first start with Senator Mcclellan. Senator Mcclellan, as you know, last January, Virginia became the 38th state to ratify the ERA. And again, we will talk about the history of the ERA, but this was incredibly significant for a number of reasons. The ERA was first introduced into Congress in 1923. It was voted out of Congress in 1972, but languished as it waited to be ratified. At first, it was very popular and the ratification at the state level came very quickly, but then it sort of stalled out with just 35 states ratifying when the deadline expired in 1982. So Senator Mcclellan, can you explain to us the special significance to Virginia ratifying the ERA during 2020, the centennial year for the 19th Amendment? And are there connections that we might draw between the 19th Amendment's understanding of equality and the ERA's vision of equality as well?
Well, thank you, Melissa. And first, it's a pleasure to be here with everyone. And I think the significance of Virginia being the 38th state really goes back to how this country was founded. We were the first. And in 2019, we commemorated several very important anniversaries that I think lay the context of how our nation, how our government was founded, and why the 19th Amendment and the ERA were sort of a continuation of a long battle. We were founded as a business venture by British, or then English white men who came to Jamestown to found a colony. And then in 2019, they founded the first representative democracy in the Western Hemisphere, the first government by, of, and for the people. A month later, the first recorded Africans arrived on our shores at Point Comfort to serve those men. And then in November of that year, the colonists realized, hey, if we're gonna make it as a colony, we need women, we need wives. And so English women were recruited to be wives, but they had no rights in and of themselves. And so when you think about the fact that representative democracy founded in Virginia was built on that hierarchy. And then in 1776, a Virginian, he didn't write all of it, but I mean, he gets the credit for it. You know, Thomas Jefferson writing the words, you know, that became the foundation of a brand new nation, and that life, liberty, and the pursuit of happiness are inalienable rights available to all men, that all men are created equal. And then when the Constitution was framed based on the Virginia Plan written by James Madison of a government by, of, and for the people, the 400-year struggle has been, how do we make that true for everybody? And the point of a government by, of, and for the people was that people's political views, their policy views, are shaped by their life experiences. And so the government and the policies it will create will center the life experiences of those who dominate. Originally, white English men, eventually African Americans, women, and immigrants, but we are not fully reflective of the full diversity of our Commonwealth or our nation. And when you think about how Virginia was at the forefront of this exciting experiment, but was also the birthplace of slavery, was also the birthplace of massive resistance. The fact that Virginia, who has been on the right side and the wrong side of history so many times, was the 38th state, I think was poetic justice. But also showed how far we still have to go to make the ideals upon which this country was founded true for everybody.
That's a really terrific point. It also reminds us that the 19th Amendment, when it provided women with the vote in 1920, it was a historic move forward, but not for all women. So could you say a little bit about the coalition of women that both enacted the 19th Amendment in 1920 and how different it was from the coalition of women in Virginia that helped to ratify the ERA in 2020?
Yeah. So I think about, you know, both times you had Black women in the fight, but in, you know, 100 years ago, we were in some cases literally relegated to the back. So I think about the Suffragette March in Washington, when the 22 founders of my sorority, Delta Sigma Theta Incorporated, as their first public act as a sorority, went to march in the march, and yet we're told march in the back because we don't want to offend you know, Southerners. Ida B. Wells being told march in the back and refusing. So we were there, Black women were there, but we were hidden. And our role erased. And frankly, it wasn't until this year that the Encyclopedia of Virginia website was changed to highlight more the role of Black women suffragettes in Virginia, like Rosa Dixon Bowser, like Maggie Walker, who you really had to search to find their voices because they were just erased from history. Fast forward, I remember 2 years ago when the Equal Rights Amendment was brought in the Senate. I happened to be sitting in the audience when it was brought, and I co-patroned the resolution then. I supported the resolution then, but when I looked at the audience and it was carried by a white man, and I thought, this room is full of middle-aged white women. Yet where are the young people? Where are the Black women? Where are the Asian women? Where are the Latinas? And that's when I knew we have to make sure that the second wave of freedom fighters for women's rights is reflective of everyone who needs to benefit. And so there was an intentional effort to be sure we had women of color as part of the movement. And then this year, the resolution was carried by 3 multi-generational Black women. Myself and Senator Mamie Locke, who was a baby boomer, I'm Gen X. In the Senate, Jennifer Carroll Foy, a millennial in the House. We intentionally did that to say, this has to include women of color and women of all generations, because all of us need the our perspectives heard if we're going to achieve true equality.
That's terrific. I'm going to step back a little bit. So we've gotten a sense of the connections between the 19th Amendment and the current push toward the ERA, but I want us to step back. We are celebrating the 100th anniversary of the 19th Amendment, which of course gave women the right to vote. But as Reva Siegel reminds us, when the 19th Amendment was framed, it was not exclusively about the question of suffrage. In fact, it was much more expansive. The women's rights advocates of that period recognized in the 14th Amendment that it wasn't simply about emancipation, but really about the question of citizenship and renegotiating the relationship between formerly enslaved persons and the government itself. And they also wanted to be included in that movement. They wanted women included in that movement. And one of the rallying points for them was this idea that if slavery was a domestic relation that was completely reorganized by Reconstruction, then other domestic relations like the husband-wife relationship and the family could similarly be reorganized to admit women as equal citizens as well. They did not get that in Reconstruction, but they still kept pushing. So Reva, can you explain your view that the 19th Amendment is simply not about voting alone, but rather was intended by those suffragists to encompass a much more radical and expansive vision of women's equality?
Sure. Thanks, Melissa. So I think that it's important in making sense of the Centennial and the text of the 19th Amendment and this whole story to go back to understand how it is that Americans or American men made sense of the restrictive distribution of the vote. How could they justify limiting the vote to men only, for example? And an important way in which they did that was through the family. That is to say, the vote was distributed on the understanding that a male head of household or a white male head of household, the minority of the polity, was going to vote. Some would vote on behalf of others. They represented the dependent and in-law subordinate members of their household. So from the law in which this question grew up, the two were inextricably tied. So that's one ground of connection. The other is that those who fought over the vote imagined that the vote was good for something. It was good for empowerment. So in the first instance, the men who justified restricting the suffrage said, well, men represented the interests of all in the household. But those who didn't have the vote could differ, and they often did, and said that they didn't feel well represented in the law that was enacted by a restricted a voting base. And so women seeking the vote often talked both to themselves, to men, to those who tried to mobilize about what a vote would do for them. And many focused on the family, although I'll say that as the group of women who mobilized for the vote expanded its base, the ways they talked about the injuries they suffered became as complex and rich as the sort of fabric of the suffrage movement itself grew to be. So many women are diversely situated in their own relationship to the family and their family's relationship to the state, working women, women of color, and they would talk about their need for empowerment and what the vote would do for them. So that's the short answer to the question. Simple and clear answer is everyone who fought about the vote in the decades from the mid-19th century to the present understood the family was at the center of it. This is no modern thesis. This was the ground of struggle. If you looked at the suffrage cartoons and postcards, it's all full of pictures and parodies of family roles and queering the family, and everybody understood this was a struggle over family authority.
So there are actually some interesting parallels with our understanding of reproductive rights and justice today, like this idea that the suffragists had that the vote was merely a predicate to their participation and their ability to actually seek laws that would better their lives, including laws about childcare, about the provision of childcare, about allowing them to work and to keep their wages. And for African-American women, they also got involved in this fight. And for them, the question of the home and the family and family security even included such issues as lynching and anti-racist issues. So, I mean, it was much broader, perhaps, than we envisioned. So can you say a little bit about how all of these things came to come together? And then ultimately, what prevented the 19th Amendment from being seen as broadly as it was envisioned?
So there certainly is an amazing array. If you look at, if you listen to suffrage speeches, if you look at the cartoons, if you look at the newspapers, and just consider the array of arguments, whether from the suffragists or the anti-suffragists, you'll see that there's an enormously diverse array of policy issues on the table, because women talked about needing the vote, needing power to change law, to change the way law was in their lives, shaped their lives, oppressed their lives. And there's without a doubt the question of how I protect my family, just like there's the chat that African-American families may have before sending young boys out onto the street today. If lynching is a threat to my family, then protecting my family, an anti-lynching campaign is home protection. And Martha Terrell was absolutely focused on that question along with the vote and along with childcare too. You know, so there's an array of issues that shape the well-being of family, and all of them are a part of the vote for women. So how is it that the 19th Amendment is construed as a just narrow issue concerning the vote? Well, I'm going to read you the text of the amendment. The right of citizens to vote shall not be denied or abridged by the United States or any state on account of sex. And so we have a provision that looks like a non-discrimination provision, a rule that says don't discriminate on the basis of sex, but it seems to refer to voting. And one way of understanding what happens here, we can tell many stories about it, but it's read as a formal rule stripped of the collective memory, of the understanding of the struggles in which it was embedded. So when this hour started, we heard a wonderful account from Senator Mcclellan about the founding of Virginia that located or centered the meaning of the vote and told us how to think about that question. But if those who fought for the vote were not in positions of authority to decide cases, to make laws, to teach law students, to essentially help reproduce the meaning of this amendment, it would help narrow the meaning of the context is shorn away from it. There are also really interesting questions of the ways in which a lack of enforcement of the 19th Amendment may have helped narrow it at the time. At least Paula Monopoly has a book coming out, which she argues that the move to go straight to the ERA helped redirect attention to a new piece of text. And also Alice Paul's nervousness about bargaining with the South to protect an ERA because of concerns of Southern fears of enfranchising African-American women in the South may have led her to be skittish about pushing enforcement actions for the 19th Amendment that could have put a lot of these issues on the table. I'm saying a lot of things at once because I know we're short on time, but there are multi-issue explanations here.
That's a great summary of things. So as Reva said, the ERA was introduced into Congress in 1923 on the heels of the ratification of the 19th Amendment. And in many ways, it was meant to go beyond simply the question of suffrage. It was really supposed to encompass that more expansive vision that had been lost in the quest to secure Southern support for the 19th Amendment. So Julie, with that in mind, can you tell us why it took so long for the ERA to make its way out of Congress? It was introduced in 1923. It doesn't make it to the ratification process until the 1970s. And then what happens to it after that?
Great, thank you. So I think if we pick up on the story of the ERA's introduction, of course, it was concerned with issues of women's inequality within the family. Part of the reason Alice Paul and Crystal Eastman and the National Women's Party started working on a new amendment was that they thought the vote was only the beginning, but there were many laws that discriminated against women and excluded them from property rights. In many states, women did not have equal parental authority as mothers over their own children. And therefore, if they got divorced, their relationship to property and their own children was very precarious under the law. And so they wanted a law, they wanted an amendment that would wipe out those sex distinctions. But one of the difficulties with such an amendment was that many suffragists, many women who actually worked for the vote, including Florence Kelley, many women who worked with women working in industry, were concerned that an equal rights amendment would wipe away every sex distinction that existed in law, including those that were intended to protect women working in industry. Now, of course, those protections for women, the labor protections for women working in industry, dated back to the days when women couldn't vote at all. And so there was this thought that women, particularly because they were mothers, but also because they were just in general economically dependent and without political power in the form of the vote, were more easily exploited and therefore required special laws, including minimum wages for women only or regulations of working hours for women only. And so there was a fear that if there was an ERA, those protections would be lost. And it was a somewhat reasonable fear because this was the Lochner Court that had struck down various labor protections since 1905 that were intended for everyone, carving out a special exception in Muller versus Oregon for labor protections that were for women only. And what's really shocking and interesting right before the ERA is introduced is that the Supreme Court decides Atkins versus Children's Hospital, which strikes down a DC law on Fifth Amendment grounds, which provides for minimum wages for women. And when the Supreme Court strikes down minimum wages for women only, it cites the 19th Amendment and says 19th Amendment is evidence that inequality of the sexes is coming to a vanishing point. It's on its way out. So women don't need these protections anymore. And meanwhile, women's wages actually plummeted after the Atkins decision. And so a lot of the women who are interested in labor protections in general, of course, what they really wanted was judges and courts that would expand those protections that women had to include men and to expand labor rights generally. But they were not confident with the court that they had that that's what they would end up with. So their vision of the ERA was more legislative. But as a general matter, it's not just the division between women with regard to their predictions of what's likely to happen with an ERA that stalls the ERA for as long as it does. I mean, the main explanation is that there are very few women in Congress for decades, even after the 19th Amendment is passed. And even at the moment when the ERA actually gets out, gets the 2/3 votes in Congress, there are only 10 women in the House and 1 in the Senate in 1970 when Martha Griffiths gets it out to the floor on a discharge petition. But of course, these divisions about labor rights kept some of the opponents in Congress, they opposed to the ERA. And so one of them, Emanuel Seller, who chaired the House Judiciary Committee for over a decade, just kept it bottled up in committee. So it didn't really get a fair debate until Martha Griffiths' discharge petition in August of 1970.
So the fact that it comes out of Congress with just a minority of women supporting it means that it had broad bipartisan support from a lot of men. So that's worth thinking about. It's also worth thinking about that the ERA comes along with other legislative attempts to sort of enact that vision of family equality that heretofore had not been seen. And so today is not just the 100th anniversary of the 19th Amendment, it's also the 50th anniversary of the women's strike. So Julie, can you tell us a little bit about that episode in history, which is probably not well known to most of the audience? I think you're muted, Julie.
Hi, sorry about that. I was trying to do 2 things at once. I wanted to get up some slides to show some images of the women's strike for equality, which took place exactly today, at this moment, 50 years ago, in New York, but not only in New York, actually in 40 cities across the country, where after the House voted by an overwhelming majority to pass the ERA, the Senate, it was stalled in the Senate, however. And the women's strike was not only about the ERA, but about all the things that the women's movement thought were necessary to make equality real for women. And central to their demands was reproductive freedom, as well as childcare, universal childcare, because as as Bella Abzug and Eleanor Holmes Norton said at this rally, the commitment to equal opportunity, or the mandate for equal opportunity in the workplace, would be an empty mandate if women didn't have some place to leave their kids while they were working. And so what they had at the women's strike here, I'll show you some images. So their demands were free abortions, free daycare, and equal pay. And you could see that on the poster there. You could see that these women are carrying babies. One feature of the strike that took place on August 26th was the baby inns. So they went to these parks in the city and said, you could leave your babies here, you could leave your kids here, so that, because even to participate in a protest, to exercise what political power you had, you needed to solve the childcare problem. Women were unequal in American society because of women's traditional role in childbearing and child rearing, which is why there were these twin demands for both free access to abortion as well as 24-hour childcare. And these were connected, these demands in the protest were connected to what was going on in Congress, because at the same time that women in Congress were working on the ERA, those same women, and particularly women of color like Shirley Chisholm, the first African-American woman elected to Congress, Patsy Takemoto Mink, the first Asian-American woman elected to Congress, they worked together on the Comprehensive Child Development Act, which would have created childcare on demand, essentially, for everyone, every child in the country, through grants and aid through to the states, regardless of ability to pay. And they were holding hearings on that at the same time that they were advocating for the ERA. Now, of course, the Comprehensive Child Development Act, even though it also had tremendous bipartisan support, ended up being vetoed by Nixon on the grounds that it would weaken mothers' connection to their children, mothers' role in raising the children. And so this was something that was also very contested. That is, on the one hand, proponents of the ERA knew that the inequalities women face that needed to be resolved through constitutional and other law stemmed largely from women's role in childbearing and child rearing. On the other hand, it was widely perceived, and certainly the opposition formed against the ERA shifted away from labor rights as such towards this notion that if women had equal rights in all these domains, then their role as mothers would somehow be threatened, and then the American family would be threatened.
That's terrific. We've mostly told a story about legislative change that centers the work of representative deliberative bodies. We have not really talked about the courts. But Riva, as you've written about in the past, the courts are alongside this change that's happening in the constitutional and legislative arena. So can you say a little bit about how the ERA, or the possibility of the ERA's ratification, informs constitutional jurisprudence during the same period of time?
So one of the interesting features of this story is that it's cumulative, and that the development of this constitutional law is happening concurrently. So we've really focused on two pieces of constitutional text here: the 19th Amendment, which was ratified, and the ERA, which hasn't, or might be in the midst of being ratified. But we haven't talked about the Equal Protection Clause of the 14th Amendment, which we understand is the locus of constitutional law that addresses issues of sex and race discrimination as we know it today. And what's striking is that until the 1970s, the court had never struck down a law as discriminating on the basis of sex. And it's only in the wake of this mobilization, only in the wake of the press or the push for the Equal Rights Amendment, that the court responds. And in fact, the Frontiero opinion, which, if any of you have studied sex discrimination, is one of the key early sex discrimination cases, is one in which Justice Brennan's plurality opinion openly acknowledges that Congress's actions sending the ERA out to the states counts as a reason for the court itself to consider then adopting what he says strict scrutiny for questions of sex discrimination. So without going down that pathway, I just want to make sure that people appreciate that the energy from outside the courts makes itself felt inside the courts, and the court begins to pay attention to the ways in which principles of equal protection of the law, which had been enunciated for decades and decades in the American legal system, actually applied to features of the family and women's lives. And also the Congress, which had adopted the prohibitions on discrimination in employment, federal employment discrimination law, was moved for the first time to really impel the EEOC to start enforcing those provisions in cases of sex discrimination. So those were two very dramatic developments that flowed from all of this. And of course, we also know that the Supreme Court makes its decision in the abortion cases also in the wake of this set of developments. So we can see the interactions. And I want to say in the end that as we look at this today, and we can maybe talk about this more in the Q&A, I think it's important for these provisions to be read together rather than disjointedly as if they were all separate pieces of text.
Excellent. I'm going to just sort of try and bring this together and bring it up to the current period. So Julie alludes to this in her remarks, but the ERA, as we know, does not ultimately get ratified by 1982, which is the final deadline that was extended. And a lot of the debate over the ERA and the contest over it comes from the work of Phyllis Schlafly, the St. Louis housewife, who is really pivotal in swaying public support against the ERA. And as Julie says, part of her plan was not only to emphasize the stripping of privileges, but the idea that an ERA would fundamentally change the nature of American family life. Fast forward, in 2017, the ERA becomes again a subject of discussion as it becomes ratified again by the state of Nevada. Illinois follows, and of course, as we heard from Senator Mcclellan in 2020, Virginia becomes the 38th state to ratify the ERA. There are questions about whether Virginia's ratification of the ERA is all that is needed to actually include this amendment in the Constitution. So Senator Mcclellan, can you tell us a little bit about that controversy and Virginia's own decision to enter into a lawsuit to force the issue and to have the ERA included in the text of the Constitution?
Yeah, so there are two sort of legal questions. One is whether the deadline put in place by Congress blocks the ratification, and then I think the question of whether those states that attempted to rescind their ratification means that we're not at 38 anymore, which are two of the reasons that the current administration is used to say they're not going to have the archivist sort of officially certify the amendment. And so a number of states, Virginia being one of them, did file a lawsuit to force the archivist to certify that the ERA is now the 38th Amendment. And again, I think it really should come as no surprise that any time the franchise or political power, and what we're really talking about is political power, because we're really political, economic, and social power. Whenever political, economic, and social power has been expanded to a new group, there has been a fight that has involved not just legislatures, but courts, and sometimes protest. And so I think this is just one more example of how we have to continue that fight using all branches of government, as well as people, through the protest or through the vote, making their voices heard. But that case is pending. The states that attempted to withdraw their ratification have intervened as well. And I think it'll, I'm not exactly sure when we'll get an answer on that, but I'm not even sure that'll be the final answer. So more to come.
All right, so we are exactly at 8:10 when I said I would open this up to audience Q&A, so I'm killing it on the moderator front. And we have a perfect question from Leah Dorn, who would like to know, she says, the ERA specifically talks about equality on the basis of sex. How might this amendment be looked at differently today with new ideas and definitions of sex and gender? So this is open to everyone on the panel.
So I'll start on that, because that was part of the debate, the floor debate. And as you see now the entry of transgender and non-binary individuals into the political process, that was squarely a question. And I remember with the floor debates in Virginia, one of the arguments against ratification used by some social conservative members, and this is, I'm paraphrasing, but this was an actual floor speech, was an argument that you would have not only women forced to be in combat, but your daughters would be forced to live in dorms with men or use bathrooms with men, and they would get raped. That is what one state senator basically said on the floor. So, and the same intersectional tension that we saw 100 years ago between the races, we saw a little bit in the fight now as cis women were nervous about, do we talk about what impact this would have on non-binary or transgender women? Do we talk about what impact this would have on reproductive freedom? And at the end of the day, we had Danica Roem, the first transgender woman elected to the Virginia legislature, was a co-sponsor of the amendment, because we said, look, this is about equality expanding to all, whether you're a man, whether you're a woman, whether you're non-binary. And so that was expressly part of the tactic used by some of the opponents to the ERA to block it. And at the end of the day, it just didn't work.
That's helpful context. Thank you. So another audience member would like to know, the 19th Amendment didn't live up to its full promise because society wasn't able or ready to grasp its full implications for women's roles. Is it fair to say that the ERA foundered because society understood too well what the implications of the amendment would be for women? Riva, Julie, do you want to weigh in?
Julie, you start, and I'll see if I have something to add.
Yeah, so I think the ERA foundered because, well, for a lot of different reasons. I think one of it, I think there was actually a lot of confusion as to what the ERA would actually do. And there might have actually been agreement underneath that confusion as to what a body of law around sex equality really should do. That is, I think there was recognition that discrimination against women should stop. But I think both the proponents and the opponents did not sign up for an ERA that would get rid of every imaginable sex distinction. The proponents wanted sex distinctions to be scrutinized more than they had been by courts or really by anyone. And they wanted to get rid of sex distinctions that actually stereotyped women and kept them subordinate in society. But the proponents of the ERA and the proponents of gender equality in interpreting the 14th Amendment, including Justice Ginsburg in United States versus Virginia, always understood that there might be room for making sex distinctions, particularly in the context when necessary to overcome women's subordination or underrepresentation. And so I think both the proponents and the opponents understood that there was room for the recognition of difference, although they may have disagreed about where those spaces were exactly. But unfortunately, I think the main reason the ERA failed was that there was a lot of fear of this rigidity of sex distinction. And in some ways, maybe there was a convergence then in that I think both the proponents and the opponents wanted to preserve certain forms of sex distinctions. And so it was that kind of agreement that led to not having an ERA.
So I'll just throw in one brief point that I wanted to make here, which actually comes out of some of what Julie was saying, which is that, I talked earlier about the ways in which this story is rich, not just as separate pieces of text, but of a historical experience that's cumulative over time. And one of the things that we can see in this story is the nation and different groups of men and women struggling with their understanding of what it would mean to have a genuinely gender equal society. And the stakes of that understanding are evolving through these disputes. Partly there's changing circumstances and norms about roles, but one of the things that's going on in the 70s and 80s, I think, is that people start with a world in which there are many, 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 many barriers on the basis of sex, and the leading meaning of the ERA, and for that matter of sex equality, is non-differentiation. But by the 1980s, there begins to be a focus on many areas of life that are dominantly concerned or where women are engaged or vulnerable or doing their work or whatever. So whether it's custody or violence or care, and those issues start to come to the foreground of the campaign for equality. But at that point, the ratification process is basically at the deadline. So the question of what the focus of the debate over the ERA is basically up in terms of the timeline there. But our conversation today about the focus of the ERA may be focused on a different set of issues. Pregnancy, sexual assault, and sexual violence. I don't know that those were the focal point in the late 70s as much as they might be today. So there's an interesting way in which the continuing dispute is forwarding a new set of issues that really are at the core meaning of inequality for women across race and class in a lot of different ways. So I'm just throwing that out there as a possibility.
Well, relatedly, there's another question in the queue that I think dovetails nicely with that. And Senator Mcclellan, would love for you to jump in as well. Are there any sex-based distinctions that are helpful to women? And if so, would those survive an ERA were it to be included in the Constitution?
So yes, but so what's been interesting, and I'll take sort of pregnancy and nursing. There are many times in the workplace, you know, as we have more and more of the workforce as parents and both parents working, there are many times when a man will have a medical condition that requires an accommodation at work, and he gets it. But if a pregnant woman or a nursing woman or someone who is recovering from childbirth requests an accommodation, they're not given it. And so many states, and Virginia now became, I think, the 28th state, have adopted pregnant worker fairness bills that say you have to make reasonable accommodations for pregnant women, you know, lactating women or women with similar conditions, precisely because those distinctions weren't, it's a distinction, yes, only women get pregnant, but both women and men have medical conditions that require accommodations, and yet pregnant women weren't getting them. And it goes back to Julie's point about the view of, well, the workplace was more for men and not women. And so I think that is the best example of how a distinction is needed to overcome other distinctions that were made in the past.
Perfect. Can I stay with you for a minute, Senator? And then I also have another question I want to pose to Julie and to Reva. So my question for you is, can you link the Me Too movement and sort of maybe perhaps make connections between its emergence and the renewed interest in the ERA? And then for Julie and Reva to close out, if you are an originalist or someone who believes that the Constitution should be interpreted using originalist methods, how do you interpret the ERA given its long ratification period? And how does the rise of LGBTQ visibility in the conservative legal movement affect the ERA and its prospects for being included in the Constitution? So Senator, I'll go to you first.
Yeah, so I think the Me Too movement is related, but I want to answer it a little bit more broadly. And it goes back to why it was so important to have the 19th Amendment to allow women to vote. And it goes back to the fact that we established a government by, of, and for the people. And yet, if only men are allowed to participate for over 100 years, all of the policies put in place center men's perspectives based on the time when women's role was viewed as in the home. And it wasn't until you started to have, as a result of women being able to vote, more women getting elected to office and their experiences, whether it's I'm someone who experienced sexual harassment. I'm someone who's experienced pregnancy discrimination. I'm someone who can't get childcare. I'm someone who, as a single mother, head of household, fighting for COVID relief that centers single women heads of households. And so I think that's how it's all connected, is unless our perspectives are considered in policy, which doesn't happen if we aren't at the table to create policy. And I think as more women have gotten elected to office, as more women have heard through not just elected representatives, their stories told, it has given them the courage themselves to speak out and tell their stories, whether it's a Me Too story or a pregnancy discrimination story, or I couldn't get access to abortion care when I needed it story. So that's how all of this, I think, is connected.
And Julie and Riva, do you want to weigh in a little bit about how originalism, the conservative legal movement, as well as counter movements on the progressive side might affect the prospects for the ERA being included as constitutional text?
Sure. So if I could actually pick up on what Senator Mcclellan was just saying to answer that question. One thing that's really interesting, and you see it probably most in the Illinois ratification, more so than in Nevada and Virginia in recent years, is this connection between the Me Too movement and ERA ratification in Illinois. They're directly responding to allegations that were made in the wake of the Harvey Weinstein allegations having to do with what was going on with Illinois politics and men in the Illinois legislature. And there's a task force that's created in Illinois leading to more legislation around sexual harassment. And that's in the nexus of ERA ratification. And I think that matters because one of the things that they really talk about with regard to the task force, and one of the insights that's emerged from the Me Too movement, is that it's not just about sex, like sexual relations. It's about power and abuse of power, and power that can get abused because of gender imbalance in institutions of power. And so it's directly related to this question about when it makes sense to make sex distinctions in the law. We've moved towards gender neutrality, but I do think that in the realm of trying to counteract gender imbalance in institutions of power, and I'm thinking of a law that also grows out of Me Too in California, requiring that every corporate board of directors have at least one woman, right? That's a gender distinction in the law. And there's a very interesting question now. Is that compatible with the Equal Protection Clause? It's being litigated. There are conservative groups that are suing to have that law struck down. And I think given the history of the ERA as being equal rights as a way of achieving equal power, that's the way that Polly Murray talked about it in her ERA testimonies in 1970, I think it's much more likely that you'd have an analysis of power in the context of interpreting the ERA that comes not only from the 1970s, but through the transgenerational synthesis of the amendment through its 21st century ratification. And it goes to the originalism question, because the ERA is really a very interesting and strange kind of amendment, because it's been ratified across generations, and it's been ratified by states at different moments in legal history, where the Equal Protection Clause was doing some things when some states ratified in the mid-70s, and has been doing other things, including anti-affirmative action things for many years by the time that the post-deadline ratifying states have ratified. And so I think there is a transgenerational synthesis that can maybe actually be described as each originalist, because we're thinking about the public meaning created through the intent of framers at different historical moments and then synthesizing them.
Riva, do you want to weigh in?
So the first thing I want to say is that one way of talking about different views of getting at the meaning here, asking on what does it mean to to give equal rights on account of sex, is to ask whether this amendment is going to be understood as just requiring non-differentiation, or we're going to look at it as ending subordination on the basis of sex, whether we're going to use an anti-subordination analytic. And I think that if one looks at the ways in which this was argued over in Congress back in the 70s, and if you look at the ways that claims are made about it all the way up to the present, you can hear a lot in the words of the proponents, both on the Hill and on the streets, about why it is that women need the amendment that has to do with ending, abuse of power, empowering women, ending injuries that make women second-class citizens. I mean, the record in the 1970s is full of that kind of talk, which is classic sort of anti-subordination kind of talk. So what is the significance of finding that language back there in what the Congress said, or finding it in the ways that we talk now, whether we're talking about Me Too or the significance of violence against women or pregnancy discrimination in working people's lives? Well, the significance is that these understandings certainly are relevant under many versions of interpretation in understanding what that text might mean going forward. If we're going to ask it in terms of original public meaning or some version of originalism, if that's going to be our going method, and I want to say in closing that we don't have to embrace that method, but were it our method, then certainly everything that's said around the amendment up to the point of ratification is going to bear on our understanding of its meaning, okay? We could go on about that a fair amount. I'll point out just for, given the hour, I'll point out just for an interesting point of comparison that when Justice Scalia talked about the original public meaning of the Second Amendment in the Heller case, he looked at events that reached well before ratification of the Second Amendment, and for decades and decades and decades after the Second Amendment in trying to deduce what its meaning could be. So on that view of things, the entirety of the ratification debates in the last half century would bear on our getting at the public meaning, and possibly even afterwards. I'll end by saying to people interested in constitutional interpretation out there that anyone who's interested in getting at the meaning of constitutional text certainly can take into account the understandings of those who ratified without committing to originalism as the exclusive method of interpretation. So I just had to throw that in there. Okay.
Duly noted, Riva. We have exactly 2 minutes, so I want to give each of our panelists 30 seconds to make some final closing remarks. So Senator Mcclellan, can we start with you?
Yeah, I think, again, the importance of the 19th Amendment and the ERA is just making sure that we bring true the ideal of a government by, of, and for all the people that centers the needs of all people. And it's the latest in a 400-year struggle.
Excellent. Julie?
Oh, well, I know I only have 30 seconds, but I would say that the ERA has taken a really long time. But there was a deadline that was put on it, and now we're going to have a lot of controversies in both courts and in Congress about the validity of the deadline. And regardless of who you think is the right decision maker on that question, I do think that having a deadline on the ERA was actually not a good idea from the beginning, in light of what we know about how long it's taken, how long it took for women to get the vote without the vote. And what it means to make constitutional change under conditions of inequality. And I think that is an insight that whoever the decision maker is needs to take into account.
Terrific. Riva?
So this morning I taught the Marbury case, and from beginning to end, only men. And too often when I teach constitutional law, only men. And one of the wonderful features of this story is that it features a wonderful array of diverse constitution makers. And I think it's really important on the theme of making constitutional law and making constitutional meaning that we enrich the stories that we tell about where our law comes from and how our country was made. And I give to Senator Mcclellan's opening remarks as exemplary. The stories we tell matter. I give to Julie Sook's book as exemplary. The stories we tell matter. It matters to know that those who made our law are richer in their backgrounds and experience and biographies and communities of belonging than the ones that you're getting in constitutional law. And to tell the stories about the Constitution's meaning with reference to them, even if they didn't have the vote at the time they were making their arguments or engaging in the forms of resistance they were engaging in. And that's the most powerful feature of all of these pieces of text, because just as much as the 19th Amendment was made to mean less, anything can be made to be less. You need to get judges appointed, it's true, but mobilized people will make a meaning if they can tell stories that matter about who we are. That's where I'll stop.
That's a terrific point to end on. The idea of just collectively broadening what it means for public memory and the history that we all hold dear. And it also is a good reminder that this is the 100th anniversary of the 19th Amendment, but we are also going into an election, one of the most contested of our time, likely. And the vote is not simply about voting, but about so much more. So please, again, make sure that you are doing all that you can to exercise your right or to help others to do the same. So thank you for joining us tonight. Please join me in thanking our terrific panelists. And we'd also like to thank Lindsay Langhole and the staff of ACS for all of the great work that they did putting this program together. They continue to be hard at work putting together terrific programming for all of you going forward. There's going to be a program on the amendment process in the very near future, so please watch your emails for that. And of course, you can keep up with everything that ACS is doing by following them on social media at ACS Law on Twitter and at American Constitution Society on Instagram. And for the people who are over the age of 40, there's also a website, www.acslaw.com. Thank you.